I told, I called a lawyer. They said they didn't have a lawyer for me.
Sir, you have interrupted me constantly through these proceedings.
I'm sorry.
Now are intending.
I apologize.
No, do not interrupt me again. Arbor One versus Shalea Wallace Napier.
Cheryl Wilkup on behalf of the plaintiff.
2 weeks ago, we said that I was going to turn in the keys, and on that Thursday, and I didn't have to come to court. But Grace from SOS said that last week I was still called. So,
and as of last night, my clients indicated they still don't have keys.
I turned them in the drop box. There's a drop box right outside the office door. I turned in the keys the previous Thursday. Around like
so you didn't hand them to anybody?
No, I put them in the drop box because I don't have a car. I don't have any transportation, so I had to get a ride up there, and I didn't get a ride till like 6:30.
So what type of identifying information are on those keys? Because
it's just the the door is to the first glass door, even though that's always unlocked. There's a key for that.
No. Is there anything on there that would identify that it was your unit that the landlord would know?
A black type of link keychain, like those type of little clip chain things they use for like rock climbing and stuff. Though one of those is like a tiny black one that the keys are attached to.
So you had a caliper on it. I don't know how I know that thing. But you had a black caliper on it. It was like a spring lock kind of thing with the Got it.
I'll call my client, Your Honor, if we can pass this, just so I can get some confirmation. Okay.
All right. Let me pass your case also. Okay, ma'am.
Okay. Does that mean come or stay on here?
Yes, please.
Okay. No worries.
I still gotta send.
Okay. You still gotta send. Oh, okay. And then Arbor One versus Nita Baptia. That matter is dismissed on plaintiff's motion without prejudice.
Thank you.
Arbor One West versus Jack. Is it Zurich? Yeah, no, I'll get it eventually, but then by that time the case will be done. Come on up.
Everybody does. Everybody messes up.
Morning, Your Honor. Cheryl Wilkup on behalf of the plaintiff.
State your name, sir.
Jack Wazork.
Okay. And where are we on this? Was this his motion?
Your Honor, it was, I don't think he can argue the motion. There was a motion filed that was drafted clearly by legal aid, but signed by Mr. Wazorek. This was a health hazard due to bed bugs and roaches and the landlord not being able to access the premises and the premises not being available denying entry and not being prepped. We took a default judgment, and I know Your Honor wanted to review this, and that's where we were last week. It's landlord's position. Go ahead. I was just say it's landlord's position. We want possession of the premises. We've had chronic issues with housekeeping, cleanliness. It's not fair to the other residents. This is an ongoing problem. I'm very willing and ready to argue that Park Forest does not apply to a health hazard. So I'm going to leave it to you what you want to hear, but I am strongly requesting a judgment here to stand.
Sure, go ahead.
Your Honor, I have had RPI in there twice inspecting my place. They never came in.
They being who?
Arbor One. Never came in. Wendy, the assistant manager, I told her that wasn't a problem. The garbage bags, like I told you last week, were not garbage. They described them as garbage. Those were pots and pans and stuff we had to put in the bags because they wanted to do a cockroach inspection. 6.5 years, I've never seen a cockroach. They turned it into, it's garbage. There's garbage all over the house. They never brought anybody in. I had paid a lady, a friend of mine, $100 after that to come in and make sure everything was in line. You got an affidavit from legal aid showing that RPI been in there twice and gave me a pass inspection. They passed me twice. Arbor One has never come in to my house. Wendy told me she got the report on a Friday. She said she'd have somebody in there Monday. Nobody ever showed up at all to do an inspection at all. I had to call RPI when I got the court judgment and bring them in on it. Which I told Arbor One, I told the assistant manager, Wendy, I wouldn't get Arbor One into it if we could help it. She wouldn't let it go. I've been having problems with maintenance in there since 6.5 years. I've been having problems with maintenance. All I'm trying to do is keep a good place. Arbor One, RPI come in there twice. They said, the inspection passed inspection. So they never come in. Arbor One never came in and did any kind of inspection at all.
Your Honor, if I may just respond to this. First of all, I don't know what affidavit Mr. Wozorek is talking about. Second of all, we're talking apples and oranges here. We're not talking about RPI. We're talking about bed bugs. We're talking about the treatment provider came to the unit on 2/2, was denied access. And then
but that wasn't
of the hearing.
That wasn't the original.
Sir, I can let Ms. Luckoff go. I let you go for a while. I just want to go ahead, Ms. Luckoff.
The date of the hearing in front of Judge Barr, they were again denied entry. This is and there are bed bugs in the unit. And this is multifamily living. I don't have to tell the court that's not fair to the other residents. So we are asking that the judgment stand and we recover possession of the unit.
Your Honor, they called me.
Sir, what affidavit? Because I don't have an affidavit either.
There's one from legal aid. They sent you a paperwork over. They sent you a bunch of paperwork over.
Who did?
Illegal aid.
Sent me?
Yes. That's who I received my that I was supposed to see you about.
Sir, hold on a moment. The only thing that I've received that I have in the court file, the only thing that I've received was the motion to set aside default supplement. And that's the document that's signed.
I have all the paperwork in my briefcase that I can show you.
Okay, but sir, did you let the treatment providers in?
They were told.
That's a yes or no?
Yes.
Not at the time that they actually came the first 2 times when we were in court. Excuse me, Your Honor, but it's important that this is clarified. On the 2nd, they were denied entry, and then on the court hearing date, which would have been the 16th, they were denied entry. After the judgment was entered, they were permitted entry.
Because they were denied. Sir, they were denied entry on the 2nd and the 16th.
Correct.
Or the 16th.
The date of the hearing was the 16th.
Incorrect.
So did they come in on the 2nd, sir?
No, they talked to my son at the office. And he told them we weren't ready at that time. He wasn't part of that.
That's a denial of entry.
I never denied him entry.
No.
They never came to my door.
If you're not ready for the treatment, that's a denial of entry.
But that was through my son, not
on
me.
The 16th.
On the 16th, I told him he could come in. I told him, inspect if you want. I said, could you wait off for a couple hours? I'm at court with on Zoom with the other court.
So hold on a second, sir. So what I'm hearing you tell me is that on that date, the unit wasn't ready to be sprayed either.
Yes, it was ready to be sprayed.
Then why were you asking them to wait?
Just because I was in court at that time. And they never gave me no warning that he was showing up or coming. It's supposed to take 24 hours notice. I didn't get no notice. They just popped in the door. I had to go to court on Zoom with the other judge. I was there. I did not deny them entry. I told them, yes, if you want to come in and inspect, come on, inspect. I said, but can you wait until a couple of hours to spray till I'm done with court? They don't give me no time. They want to do it when they want to do it. Right. They want to just
exactly, sir. Exactly, sir. They needed to come in and do the treatment.
But you know, they don't understand that we have a house we have to maintain ourselves. And when I'm on court, on Zoom, on the phone, all I'm asking for, I'll move out. I just need more time.
That's what he
That's
said
what
2
they
weeks
want.
ago.
If they want me to move out, I'll move out. I just need more time to do it. Because see, the assistant manager, I don't know if this lawyer knows it or not, but they called.
When are you going to move?
I don't know yet.
Okay, let me put it to you real straightforward. I've listened to what you told me. I've looked at everything in the file, and both of those 2 times would be considered a denial of entry for treatment of the premises.
But yeah, that didn't even start with the bed bugs at all.
Sir, if you can argue with me all you want. I'm telling you what I'm finding.
Well, do I have a right to get a lawyer or go to trial with this? Because this ain't right. This is not right. I've been haunted by this company for maintenance. The first maintenance problem started years ago.
Sir, I'm explaining to you what my finding is. Now, if you want, you have a lot of opportunities to do what you want to do. I don't have a problem with that. All right. I'm explaining to you what my findings are. Understood? Is that a yes?
Yes. Yes.
So what I'm trying to find in that the Judge Barr found that they were entitled to that, the writ should be signed. You have indicated to me that you will move, but that you needed time. So my question to you is, how much time did you need to move?
At least till like June.
Well, that's not going to happen.
Okay, because what it is Wendy, their assistant manager, called me last night at 7 o'clock and told me the lawyer told them they were coming in to exterminate today. I told him, yeah. I said, I'm not going to be there. I'm going to be at court. But they have access to come in and spray. And I'm asking, why would they do that if they're going to want us out anyways?
Because the problem that's causes problems for all of the other residents. If your unit doesn't get exterminated, everybody else in that building has a problem. That's why.
Right. I understand that. I understand that. I've been self-exterminating myself before they ever showed up. I was self-exterminating with Orthex or whatever it is. I paid $20 a gallon for it. It just didn't totally eliminate it. And I know what the problem is. I have to get rid of my couch. My couch is a major problem with them. And I'm getting rid of the couch this month. I needed money to buy another couch. And that's a major problem. It's right there. They're all in the couch. There's nowhere else in the house that they're accumulating that, just in there. And the other problem is the people that moved out before me in the building across the hall, they moved out 3 months before Arbor One discovered they moved, and they had to remove their couch and love seat because they left it behind.
Okay. All of that's fine. The problem is that the landlord, you objected when you came in here to the hearing that took place before Judge Barr. That's what you were giving me, which is the only reason that I set this where I did. The problem here is that there was a denial of entry to the premises.
But that one you got on the court docket.
It just is. It is what it is, sir.
But Your Honor, what I'm trying to say though is through the original judgment, it was over garbage bags. It wasn't over bed bugs. And they said we didn't prep for the bed bugs the first time. When they gave the court order, they never gave me a prep sheet. They never told me. They said, oh, go back to your prep sheet in December. We never got a prep sheet in December at all. They started this in January, and they said, go back to your prep sheet you got in December to prep it. Well, I never got no prep sheet on bed bugs. We get a prep sheet on cockroaches, which is total different prep. It's a total different prep for cockroaches and bed bugs. We never received a prep sheet for bed bugs, so we didn't know what to prep. So how could I bring them in and say, yeah, we'll prep, when I don't have a prep sheet to know how to prep it or what they want for prep? And even the exterminator came in there and I asked him, are you doing bed bugs and cockroaches? He said, no. He said, I didn't even get a work order on bed bugs. They didn't even get a work order on it.
Your Honor.
Sir,
Let
me just say this. Every time I tell you what I'm finding, you keep telling me something new. It doesn't work that way.
But you're going to only 2 times, Your Honor. They're going to, you're only going to 2 times.
You can keep interrupting me all you want.
I'm sorry. Sorry.
It's not going to change my decision.
I'm sorry. It's just.
There was a hearing that was held on this. The hearing, I don't find a defect in the hearing. I don't find a defect in the hearing. The judgment will stand. The writ will issue.
How long?
I'm done. The writ issues. It's a statutory. There's no period, sir. There was a hearing that was held.
Well, how long do I have to move? I'm saying, how long are they going to give me time?
I just signed the writ, sir. So you're operating on borrowed time.
Well, because I'm going to lose my Section 8. If this writ goes through, I lose my Section 8. And I have no other way of paying my rent or anything. I've been there 6.5 years, paid my rent, never gave a problem at all to them. And because of bed bugs they're supposed to eliminate, I'm being accused of something I didn't even do. I haven't even done anything that is causes warrant for me to be evicted. That's why I'm asking. I just need a little more time, yeah. You know, I need at least a month. And now, if they're causing on a writ, that means they're evicting me. No place is going to touch me with an eviction. You understand what I'm saying? I go to some place, tell them, oh, I got evicted. I'm hit. I'm 60 years old. I don't have time for that. I was trying to retire. I told them up front, I would work with them on stuff. I said, no problem. I'll work with you. We got to work with it. You know, I don't know what else to say. I was never given a lawyer. I have to sit here and defend a lawyer when I don't have that kind of smarts. You know, I'm not that smart to deal with a lawyer. You know, and I'm not even given a chance
Sir, do not come before me and tell me that as a tenant, you're not given a chance, not before me, because that doesn't happen before me.
Your Honor, I called a lawyer. They said they didn't have a lawyer for me.
Sir, you have interrupted me constantly through these proceedings.
I'm sorry.
Now are intending.
I apologize.
No, do not interrupt me again. You now want to insult me by saying that somehow or another you don't get a fair hearing when you came here. When you came here the first time, I told you what I would do. I read your motion. I went through everything to see whether or not there had been something, because you claimed a number of defects. I then bring you back here, have treated you fairly, have listened to everything you have said. And how dare you say to this court that somehow and or another you don't get a fair hearing for me? I've made my ruling. I'm done. Thank you. I'd suggest that you close your mouth as you leave, because otherwise you're going to be going with my bailiff.
Step south.
Arbor One West versus Gwinnett Artis.
For the record, Your Honor, Cheryl Walkoff on behalf of the plaintiff.
Hello,
Hello,
what's your name?
Winetta Artist.
All right, where are we on this?
Your Honor, escrow, I believe, was released. I don't think we've received it yet, but that doesn't surprise me. At the last hearing, you released.
That was a dig. That was a
no,
dig at us,
no,
wasn't it?
no.
And
Excellent mail. Your
Alan, did
mail
that
is
sound like a
terrible.
dig? Like we don't do stuff like on
No.
time? No, go ahead. That's okay. I'm a bit sensitive.
I have to tell you, usually the notices of adjournment, we open them after the hearing, not because of the court. The mail is so bad. That's why you guys are awesome and you send us the spreadsheet so we know when we have our hearing. Anyways, nothing to do with the court. And the tenant was supposed to pay $1,000, which I believe she did. And then yesterday I was notified she paid the $152. So we are good on her judgment. I mean, she does owe March rent.
So I'll tell you what I have in that. What was my total in escrow? Because I have 2980 in escrow.
Oh, and that's been released, right? Or
all of it was mailed? Yes, all of it was mailed on the 28th.
okay. So then taking that into account, and she paid the 152. I think she paid it yesterday, but whatever, she paid it, and so it's fine.
That she paid the 152 directly to you guys then.
That's my understanding. Is that correct, Ms. Ortiz?
Yes, to Arbor when I
paid that.
Yeah, it was late. I said I was gonna pay it on Friday, but I went and spoke with Wendy, told her I'd bring it to her on Monday because I didn't have transportation to get to Kroger's. But over the weekend, somebody put fire extinguisher through my vents and destroyed my whole apartment. So that's the reason why I'm late on paying that 150.
What do you mean they destroyed your whole apartment?
I left, went upstairs to the neighbor's apartment, came back home, and my whole apartment, clothes, bed, everything was covered in fire extinguisher residue through the vents. So I had
vents?
Yeah, so all my clothes, my bed, my TVs, my computer, everything.
You know anything about that, Miss?
I do not.
No, I didn't inform her.
Okay, did you talk to the landlord
Yeah, I
about
talked
it?
to Wendy. She said that
Okay.
kids do it. It happened before kids do it, and it's my responsibility to clean it up and fix it. So
Got it. Okay,
So
but I think
the 150 was late, but I had
it's okay.
Okay, but I had an appointment with Hawk on the 26th. That was originally previously scheduled, so I did keep that appointment. She did state that they wanted to cover my March rent. But she needed a ledger that stated, what my rent would be for March with everything paid. So when I went to the office yesterday, they still,
They haven't received a check.
Yeah.
Okay, but it seems to me that has she satisfied the judgment?
Yes, I believe so. Let me just confirm.
All right. So the judgment's been satisfied. I'm going to close this case out. Okay. And then what can happen is then you can still meet with Hawk, ask the landlord to send over a ledger, and maybe they can take care of everything before you have to come back into court.
Okay.
Got it?
Yes. Can I please ask Ms. Luckoff, or will you be able to get the ledger before I would? Because when I went yesterday, they were saying, she printed me off one, but it still say I owe like $4,000, and she don't know when she'll have it.
It's going to show the 4,000 because the money that was in court escrow isn't there yet.
Okay.
Right.
So
I do have one. Sorry, go ahead, Your Honor.
Go ahead, Ms. Luckoff.
I was just say, I this morning I asked for one that has March, so I do have that. But as Your Honor indicated, it's not going to reflect the escrow payment. And I'm just going to throw this out there, Your Honor, because otherwise we're going to have to file a new case. It's just going to have new court costs. So I don't know,
Okay, that's a
March.
good point. Maybe what I'll do, why don't I do this? Why don't I adjourn this out 2 weeks rather than get rid of the case?
Okay. And Ms. Luckoff, I did send an email over to you with the contact person that I have in contact at Hawk. And I'm going to reach back out to her because she said she was going to get everything hopefully done within the first week of March.
Okay, so what will happen is if we send it out on the 28th, the check should be getting there sometime, hopefully this week.
Okay.
And then that amount will be subtracted off, then they can get you a ledger and hopefully we can get that resolved. If I adjourn it out, Ms. Luckhouse, right, if I adjourn it, I'll never say that again.
Is that recorded? Okay, yeah.
If I adjourn it out a couple of weeks, that way, if something happens, they're not bringing you back in and you get more court costs.
Okay.
So it may save you money in the long run, okay? We'll do it that way. So it'll be March 15, 2024 at 1 p.m.
All right.
Okay, is there anything you want to yell at me about?
No.
Okay, because everybody seems to want to yell at me today, so I just wanted to give everybody an opportunity. All right, thank you. Court calls the case of Sile Farms versus Melania Luckert. Okay, there you go. Hello, what's your name?
Elena Luckhart.
What is the claimed amount on this case?
Total due with court costs, Your Honor, $7,187.17.
Okay, and ma'am, what do you have to say about that?
I'm waiting on my SIR determination, and then I meet with Hawk on April 15th to get in for Section 8, and then I'm trying I need to meet with the office still. I had asked via email. I haven't actually physically gone in there, but is there a way that I can like pay on it with what I have while I'm waiting for these other things to kind of roll into place? Your Honor, I did speak with my client this morning regarding Ms. Luckhart's request for a payment plan, and unfortunately, given the balance, they're not able to do that.
All right, so Ms. Luckert, did you apply for your SER?
Hold on. I had it. Give me 1 second. I applied on the 6th.
The 6th of February?
Yes, yeah, and I actually followed up with my caseworker via email yesterday because I hadn't heard anything, and I still haven't heard back. It's still processing. I don't have any determination.
Okay. Well, you would be past any stay period in any event. You said you were trying to pay on it but couldn't. What are you telling me? I guess.
So with the state, I don't know what it is, but I'm waiting on a bridge card on food benefits. I have no transportation. My car was repoed. I had my salary job, lost that. I'm working hourly right now at the University of Michigan. I'm trying to it's a struggle. And so I'm trying to get these benefits. My healthcare was denied for a few months and now it's reapproved. I don't know what's going on. I need to talk to my caseworker. I'm having a hard time getting a hold of her. So the money that I am making is going towards buying food for the family and then rideshare to get to my job so that I don't lose it, because if I lose it, then I'm completely unemployed. So I've been hoping that, once things start to fall in place, that the money that I am making can go towards rent. And then I spoke with Hawk, and on April 15th, I'm going to go in. I have the interview set up. Already did the phone one, and I'm going to try and get on Section 8. And I know that doesn't help us now, but I have been trying to get there.
Here's the problem. I can't get you to the April 15th date. Let's do this. Amy, do we have Ms. Luckhart's email?
Your Honor, could I meet with her in a breakout room?
Okay, let's do that. Well, here's going to be the issue. I was going to find that there's no tribal issue. She's not disputing the amount that's owed, and I was going to grant the judgment to the plaintiff, but and I would make that writ date the 15th, so she'd have a couple weeks, but I'll let you. So I'm going to do that. Finding no tribal issue, I'm going to grant a judgment to the plaintiff in the total amount that's due. Okay. Ms. Luckhart, what I'm going to have you do is I'm going to have you meet with Amy in a breakout room. She'll likely talk to you about different resources that may be available to help you and your family out. Okay. But at worst case scenario, so that you understand what I did, is you'll have about a 2-week window that you're kind of working with here. Okay, to try to get things to fall into place and do that. Okay, that's the best that I can do for you. Instead of the 11th, at least extend out there. And maybe with some of the resources, if they know that that's your deadline, that may oddly cause them to act a little bit faster.
Okay.
It's a horrible way to do it, but
Yeah.
what I'm stuck with. Okay.
Okay.
All right. Thank you. So you
Thank
hang
you.
on the line. We'll put you into a breakout room with Amy. Thank you, Amy. Harbor Woods versus Victoria Harper. Miss Harper, can you hear us? Can you talk to us?
Yes, I can hear you. Can you hear me now?
Okay, great. Great. We got it solved.
So
All
I
right.
do have the $1,000 that I was supposed to pay. I guess I just confused myself. So I didn't make it. I didn't go make the payment. But I do have that to pay. And I've also applied for SER. I just received an email from them requesting verification of my employment and some other information and in my check stubs. And then I also applied for some assistance from work, which I should know about if I will receive that next week, because I have to get them the SER information.
Okay, so let me ask you this. The assistance from work how much will they potentially pay of this?
They will pay $1,500.
They would pay $1,500.
Yes.
Then you have the 1,000, right?
Right. And I'll have another 500 by next Friday.
By the 8th?
The 8th.
So you'll have another 500 by then.
Right.
Okay, that'd be about $3,000 of this amount. If your work pays and you can pay basically effectively the 1,500.
Right.
Okay. If somehow over the objection of plaintiff, I were able to get you to that point, then how would the other 2,000 get paid?
I will be able to pay another 1,500, let's say the 22nd. And then I can try to get the other 500 by the 29th. I can't say definitively that last one, but I definitely could probably pay the other 15 by the 22nd.
Okay. Let's do it this way. Your client will take partial payments, Miss Dornbush.
They will, Your Honor, yes.
Okay. So I need you to get the 1,000. I'm going to trust you, Miss Harper. You've been here before and you kind of pulled yourself out. So I'm going to trust you over the objection of plaintiff. I want you to pay the $1,000 to the landlord.
Okay.
You got to wait for the SER and you've got a plan in place, and then you know something next week about the 1,500, correct?
That is correct.
Would you know early? What time is there? 8th?
1 p.m.
Okay. Would you know by 1 p.m. on the 8th about that?
I don't know. I would say it's going to depend on how fast the SER, once I turn in my check stubs after this meeting, and they want my job to fill out a verification of employment. So I'm going to send that to them too. So I guess it's going to depend on
Miss Harper. Miss Harper,
yes.
I'm going to trust you.
Okay.
I'm going to trust you. Plaintiff's going to be mad at me, but that's okay. Everybody's mad at me today. But you get that 1,000 to them. I'm going to adjourn this out to the 15th. The number's not going to get any worse. So at 2 p.m.
Okay.
Okay. So by then we should You got the 1,500 for work.
Mm-hmm.
You're gonna pay the 1,000 to the landlord,
Mm-hmm.
and
The 500 on the
there's
8th,
not.
Judge?
And 500
Pardon?
on the 8th.
Yeah, to the landlord on the.
Yes.
She should pay the landlord today, or
Mhm.
she's to pay the 1,000 to the landlord right away.
Right.
And
can
then
we
do you
include that
have a
payment
check
8th,
on the?
Judge?
Pardon?
Can we include that she'll make that payment on the 8th since we're adjourning it 2 weeks?
What, the 1,000?
Oh, she said she has 1,000 now. She could do another 500 on the 8th. And since the court's
Right.
adjourning
That's
it.
I was getting to that.
Sorry.
I was getting to that. I know you were way ahead. See, they do that when they get mad at me. Okay, so so you can pay another 500 on the 8th, right, Miss Harper?
That is correct.
All right, so you got to pay 500 on the 8th. And so hopefully when we come back on the 15th, then what will happen is we'll be at about a $2,000 figure. We can try to work with that and see where we can head. Okay.
Okay. Okay. Thank you.
Sounds good.
Yes, sounds good.
All right. Okay.
Thank
Thank
you,
you,
Ms.
ma'am.
Dornbush, as well.
Thank you.
All right.
Ms. Harper.
Have a
You didn't do
victorious day.
anything. Miss Harper, I did it all. I don't know why is everybody thinking her, that's okay, fine.
Judge,
I think
we're not mad at you though.
Oh, okay. Yeah, that's true. That's true. All right.
All right. Have a victorious day and a fantastic weekend.
You do the same.
All right.
And
Thank
Ms.
you, Judge.
Dornbush, have a great weekend. Thank you.
Yes, Judge. Thank you.
Court calls the case of Arbor Woods versus Brent King and also Tanya Roberson.
She doesn't live there. She was just a co-signer for the place when I originally moved there.
Okay. All right, but she doesn't live there. Your name?
Brent King.
All right. And how much is owing on this? I had 1814 last time, but we clicked into a new month.
Yes, total with court costs, Your Honor, $2,494.98.
Sir, how do you intend on getting that paid?
Well, I've been off work since October due to an injury, so they just reduced my pay 40% in January. That's why I'm here now. If I can have an extra 30 days, I can have the whole balance paid off. I'm still getting paid. I just got to piece stuff together.
Okay. Okay, I got you. But
I'm still good at the job. I still get money. It's just not the same amount that I would normally get. So I could just get a little bit more time to pay it off in full. I can't do that.
Okay, let's do this. By the 15th, how much can you pay?
Well, I did apply for state emergency assistance. So if they don't respond back, like I said, I can handle everything within 30 days.
I know. But by the 15th, can you pay anything? Because I'm going to give them a judgment because there's not anything for me to try, but I can't put it out 30 days. So here's what I'm looking to do is I'm looking to say, get you your time, but give them the judgment so they can take what action if you don't pay. But I need you to tell me you're going to pay something by the 15th. That's going to give you what I'm going to do, and probably over plaintiff's objection, is give you additional time to get it all clear. You follow me? But I can't have them waiting 30 days to get paid.
We'll say half the balance.
Half of that balance would be about what, 20 or 1,700, 1,800,
I think it'll be about $1,250, Judge, but let me see if we part.
1,250. Yes, 1,250. I'm sorry, I had more, but so you can get 1,250 by the 15th.
Like I said, I still get money. It's just not the full.
I hear you. I'm trying to work it out so that it works for you and it works for them. Okay. So you can get 1,250 by the 15th. Yes. Okay. So here's what I'm going to do. No tribal issue. I'm going to grant a judgment for the plaintiff for that full amount of $24,94.98. Defendant with a writ to issue initially the 15th. However, if defendant pays $1,250 by the 15th, then writ to issue, it'll be the 29th because it'll be the 29th of March. Okay. Writ to issue March 29th. So you got to get it paid. That's the last working day. Okay. All right. Thank you. Arbor Woods versus Brandon Wilson. And somebody's coming up with him, Kimberly Slayton.
And the total due here, Your Honor, with court costs is $5,847.10.
All right, folks, what do you have to say about that? How are you gonna get this paid? Yeah.
We can get it paid by the 15th of March in full. I did talk to the office about, I think he said about $600 from the previous balance should be taken off of there because he said it was an issue with the new portal system. So he said that the beginning amount, which was, I believe, about 4,000, that was on the court papers. He said that that was inaccurate and that it was about maybe 3,500. He said that the attorney or whoever was representing for them should know that that fee should be removed from that, but we can pay in full by March the 15th, the full.
By March 15th?
Yes, sir.
Your Honor, they did do a credit on the ledger of $673.49. So this balance already takes into account that reduction.
The 58.47 takes into account that reduction that she's talking about already. Is that what you're telling me, Ms. Dornbush?
Yes, Your Honor, there was
Okay.
a credit of $673.49.
Okay, so they've already done the credit. The actual amount is this.
Okay, that's fine.
You can get it paid?
Yes, sir.
Yes.
I don't
Your
even
Honor,
know
I
why
don't have
he,
an objection to extending the writ date to the 15th.
I'm sorry, Ms.
I don't
Dornbush?
have an objection to extending the writ date from the 11th to the 15th.
15. All right. Then what I'm gonna do is I'm gonna issue a judgment, finding no tribal issue. Your normal writ date would be the 11th, but I'm gonna, without objection and actually by stipulation of counsel, your writ date will be March 15th. So get that paid by then, and then you guys are gonna be all set.
Will do. Thank you so much.
You're welcome. You know, it was
Awesome.
nice that he let the brain trust speak. And he said nothing. That was much smoother that way. All right, thank you, ma'am.
Thank you. Have a good day.
You too.